Discharge by performance is a contract that can be done by either actual performance or attempted performance. If it is impossible for any parties of the contract to perform their obligation, then that impossibility leads to the discharge of the contract. If the party repudiates a contract before the agreed time of performance of the contract, then he is supposed to have committed an anticipatory breach of contract. Good morning and welcome to the session 4 in Unit 2 Commercial Law, where we are going to talk about the discharge of contract. Now, very important, we need to understand how a contract is being discharged. When I use the word discharge, that means how it is executed. This word is very, very important for all of us to know. Why? Because discharge is not just about saying that I have done it. The way how you discharge a contract is highly important. First thing, the contract creates obligations on one or all parties involved. The first thing that we have to understand, create certain obligation on one or all the parties involved. So there is an obligation. Whether you like it or not, you have to follow the obligations that has been told here. So that's why the discharge of contract says that you have to follow certain rules and regulation. You cannot avoid it. You cannot say that, sir, this is not applicable for me. I will just go ahead the way I want to do it. So there is a contract which says that yes, there is certain formalities to be followed. The discharge of contract happens when these obligations come to an end. So when the obligation, when the formalities that has been told has come to an end, has come to a complete factor, then only we say that the end of the contract. Now, for example, there are certain rules that you need to follow when you are getting into a contract. If you have not followed that rule, if you are not gone by the book, then automatically it will become a problem. There are many ways in which contract can be discharged. In this article, we will look into what are the different scenarios. So let's first start with the word called as discharge by performance. The word performance here is very, very important. Why? Performance means how are you going to perform? How are you going to conduct yourself in terms of that particular contract? So let's first look into it. When the parties to a contract fulfill the obligations arising under the contract within the time and the manner prescribed, then the contract is discharged by performance. Very, very important. Why? Because we are time bound and manner bound. That is the way it has been prescribed. This word time and manner is very, very important when we talk about in a contract. Sir, I will do the contract according to my time, my will and wish. It is not accepted in the world of contract. The contract says that when you are trying to take up a job, you need to complete the job as prescribed. Now, for example, if I am working in Zomato, the Zomato tells its delivery boys that the food has to be delivered within 30 minutes. That means that it's a time-bound factor. Why? Because if you exceed the time, and if you are not following the instruction, the customer can come back and sue the company saying that he did not receive his parcel on time. So similarly, all the contracts will have some time limit and a specific act altogether. Follow the act very clearly. Now, Peter agrees to sell his cycle to John for an amount of 10,000 to be paid by John on the delivery of the cycle. Simple case. Peter is here. He goes and says to John that I will sell this bicycle to you for a condition 10,000 rupees, which you have to do. As soon as the amount is delivered, John pays the promised amount. So that soon as the factor, it is being delivered, the cycle is delivered, John will pay the amount. Simple factor here. If John did not pay, then the discharge of contract is not completed. A agrees to B that on the delivery of the goods, I will pay 10,000. Moment the goods are delivered, you have to pay the 10,000 rupees. So that is what is expected here. This is very, very important for all of us to understand and take it forward. Now the next thing, discharge by performance. Since both the parties to the contract fulfill their obligation arising under the contract, then it is called as discharge by performance. Now, discharge by performance is a contract that can be done by either actual performance or attempted performance. Now, we need to understand that if both the people are complying to the rules and regulation that is being mentioned there, then no need to worry. Why? Because they have done the job. It is no point to worry at all. It is being taken care of the scenario very well. But then, if it is not taken care, I have my problems, sir. I have my issues, sir. I am not going to take it so lightly. I have my factors coming into picture. Then what do I do? Then how do I take it forward? What are the essentialities that I have to look here? That's where the factors come into picture. That's where we try to say to the persons very clearly here that whenever you are going by the performance, whenever you are doing it in the actual manner, in the attempted manner as shown, what we want is there are two kinds of performance. One is called as the actual performance. The other one is called as the attempted performance. Now, as shown in the example above, actual performance is when all the parties to the contract do what they had agreed for under the contract. Now, this is very, very plain simple. Actual means what is actually told, just do that. Follow what the script says. That's all we want you to do. So when you are talking about the actuality factors here, we are just telling you, please follow what is written on the document. Do not try to exceed the documentation factor at all. So that is how we are trying to tell you about the actual performance. Whatever is being told, perform that. That's what is actual performance. On the other hand, it is possible that when a promiser attempts to perform his promise, the promisee refuses to accept it. In that case, we call it as an attempted performance or tender. Please understand the case here. Now, on the other hand, if the promiser attempts to perform certain thing, but the promisee refuses to perform it, which means the other person refuses. He says that, no, I will not try to do so. There is an attempt which is being made from one end saying that, sir, can you do it? Then automatically it is being done. So that is what we call here as the promise attempted. So this is why we call this as a very, very important function altogether. Now, the discharge by mutual agreement. If all the parties to a contract mutually agree to replace the contract with new one or with the annual to remit or alter it, then it leads to a discharge of original contract due to mutual agreement. So it's a very, very fantastic contract altogether. What we are trying to say here is that if all the parties of the mutual contract agree to replace the contract with a new one or the annual remittance to alter it, then it leads to the discharge of contract. Now, that is very, very important as a mutual agreement altogether. Why that is important here? Why? Because if the parties, all the parties, they are mutually agreed, yes sir, we will change the contract, we are not happy with it, we will replace the contract, we'll make a new contract altogether. Due to whatever circumstances or the conditions told, we are not happy with it, let's go for a change. Then what happens is that the discharge of the original contract due to mutual agreement is now being changed. You are going to alter it. Now let's look at the example. Peter owes 1 lakh rupees to John and agrees to repay within 1 year. The document in debt is under the contract. Now what happens is that Peter has borrowed from John 1 lakh rupees. So Peter goes and says to John, sir, within 1 year, I will pay you back that 1 lakh rupees. So now what happens? They document the debt under a contract. So they have put it under a contract. Now what happens subsequently in this example? Subsequently, he loses his John and he requests John to accept 75,000 as a final settlement because the scenario is bad. He has lost his job. He is not in a position to take care of his financial abilities. He goes back to John and requests him. He's not ordering. He's just requesting, saying that Please accept 75,000 as the final settlement of the loan. John agrees and they make a contract to that effect. Now, the new contract comes into place and not the old one. In the old one, they had signed it for 1 lakh rupees. But now, the new contract is coming into picture which says that 75,000 will be the amount to be settled. And John agrees to it. So, when the mutual consent is being arrived, and they agree saying that yes, for this amount, we will settle it off, the old contract is being altered. So you have to perform as per the new contract. But this is possible only and only if both the parties, the concerned parties, agree to the scenario. They believe in that, okay, fine. Because of these changes, because of these factors, I think this person is not able to do it. So let's take it forward and finish it off. So that is where we bring this particular contract factor. The next thing, discharge by impossibility of the performance. Now, what is impossibility? What do you mean by that word impossible? When you say impossible, that means that it cannot be done at all. So that's where, if it is impossible for any parties of the contract to perform their obligation, then that impossibility leads to the discharge of the contract. Now, why is that impossibility? Because there are certain factors. I am not able to do it. I am not in a position to do it. Sudden death. Something happens to the other person. Then the impossibility comes into picture. Now, once that impossibility comes in, then the discharge of contract cannot be completed, because the other end, you will not be able to do it. One person is doing it, but the other person also has to comply with him in terms of completing the contract. But due to unforeseen situation, unforeseen circumstances, that person is not able to complete the contract. So automatically what happens? Impossibility of performance comes into picture and things go away. Now, this is why we call it as the impossibility ab initio altogether. However, the impossibility might also arise later due to what factors? Unforeseen change in law, destruction of subject matter essential to the performance, the non-existence, non-occurrence of a particular state of things which is given under the performance of contract. Now, unforeseen change in law. Let me just take you back to the slide and make you understand how it has happened in terms of the unforeseen situation here. Now, there is sudden change in law. The government, the state, the court brings in a change in law and says that there is a change factor. The law itself has been changed, then automatically the discharge of contract will not be possible. It will lead to some sort of changes or some sort of factors altogether. Now, destruction, the evidence to that performance itself is destroyed. The document itself is not there. There is no state of evidence stating that this law has to be performed, this law has to be continued altogether. So then what happens? The destruction happens. So there is no need for the discharge of contract to happen at that given scenario. Followed by the non-existence or non-occurrence of a particular state of things which has been considered for given for the performance of contract. Yes, agreed. So what happens is that non-existence of that factor or non-occurrence of that particular activity itself has become one of the reasons for the non-performance of the contract. So this is also considered to be a very, very important factor by which you will start looking that yes, this is claiming to be an impossible thing altogether. Now, declaration of war. Now, this is a very, very interesting factor altogether where we are going to look for the impossibility of performance. There's a declaration of war coming into picture. So, how does it start? Peter enters into a contract with John to marry his sister Olivia within a year. Now, this is a mutual understanding. However, Peter meets with an accident and becomes insane. The impossibility of discharge of contract comes into picture. Now, a war-like scenario. Now, what is a war-like scenario is something like where, for example, suddenly that person becomes insane, suddenly the person becomes completely out of the factor, it goes out of the reach altogether, then that performance cannot be taken into picture at all. Now, the Limitation Act of the 1963 says that for a specified performance time of the contract, if the promisor fails to perform, the promisee, he can take into action within that specific period of time, then the latter cannot seek remedy through law. So that is why we say that it discharges the contract due to the lapse of time. Anything in the performance of the law of the contract has to be done within that time period. If it is not done within the time period, if it is not done within the specific time zone altogether, then automatically this would be considered to be a lapse of time factor altogether. So when we talk about this lapse of time, this is very, very important, that says that because the time has lapsed away, you cannot come back and claim. See, for example, there is a settlement claim and they say that you have to claim this before 28th of this month, and you go on 29th or 30th and start claiming that bill, it will be considered to be a lapse of time. So similarly, in contract, it is very much essential that you stick to the time factor at any given point of time. Then only you will be able to understand the value of the time factor. So this is very, very important, essential in terms of understanding. The next thing, discharge of contract by the operation of law. A contract can be discharged by the operation of law, which includes insolvency or death of the promisor. Very, very important factor for all of us to learn. Now, you have borrowed money to start a business. Now, what happens is that as you start growing with the business, suddenly the business meets a severe loss and you are not even in a position to run the business further. So you go ahead and claim for insolvency in the court of law. By claiming the insolvency in the court of law, and if the court provides you, grants you that status, the contract of discharge cannot be taken into position. So the bank tomorrow cannot come back and catch you and say that you have to repay back. Why? Because the discharge of contract says that if the person has been proved insolvent, or if the person dies under certain circumstances, condition, then automatically the discharge of contract doesn't need to flow further. It is done by the operation of law. So the discharge cannot be discharged by the operation of law because of insolvency or the death of the promisor. Now, the death of the promisor is also important. Why? Because suddenly, due to some circumstances, the person dies in an accident or some unknown cases. Now, let's even take the case of the pandemic altogether. If those kind of scenario, the person passes away, then you will not be able to claim back that money. So that's where by the operation of law, the discharge of contract cannot be completed. The next thing, by the breach of contract. Now, the breach of contract is a very, very essential word. If a party to a contract fails to perform his obligation according to the time and place specified, then we say that he has committed a breach of contract. What do you mean by the word breach of contract? Moment the word breach comes into picture, that means I have violated the norms of the contract. That means I've gone against the norms of the contract. So we are saying that breach of the contract. Also, if the party repudiates a contract before the agreed time of performance of the contract, then he is supposed to have committed an anticipatory breach of contract. The time that has been mentioned, I withdraw back or I roll back before the committed time period, then automatically I am set to conduct a breach of contract. So this is where the breach of contract is very, very important for all of us to understand. Unless and until you are following the rules and regulations clearly, and if you are trying to break in any point of time, in any manner that is being prescribed in the contract law, then automatically it is evident that you are trying to commit a breach of contract. Now, in both the cases, the breach discharges the contract. Now, when you say the breach discharges the contract, in what way? The actual breach, when the promisee retains his right for action of damages. Because you have breached the contract, now I have a right to put a case against you and claim whatever factors against you. An anticipatory breach of contract, the performance of promisee cannot file a suit for damages. It also discharges the promiser from performing his part of the contract, which is very much agreed upon. So all these factors are very, very essential and important for us, because the actual breach of contract tells promisee his right of action, damages that are being taken into position. So all these factors have to be agreed upon before we start getting into the factor, before we start understanding how the file of the suit can be taken into position. So this takes into position all the terms and conditions, all the factors, and then it moves forward. With this, I come to the end of this particular session, and I hope and believe that all the resources that have been shared through this particular session would be of a great help and resource to you. In the upcoming sessions, we shall learn more about the discharge of contract, which will make us understand in a practical scenario how the contract law works. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.